we're going to go live, which starts all the comments within a few seconds of when I go live. People start posting on the live chat, and then I have to shut it off.
Oh, geez.
Anyway, we'll be ready to start here in just a moment. I don't know whether Miss Longacre's going to show up or not. We'll be right back.
Judgment against the second defendant in this case.
Yeah, he didn't respond. There's a default against him.
Correct.
Give me a sec.
Sure.
Well, good morning.
Morning.
Today is April the 5th. It's Monday morning. We're about to do a number of civil motions and some landlord-tenant matters. I'm going to bring this person in here. Good morning, Bettina.
Good morning.
We've got our work cut out for us this afternoon. We've got a really busy afternoon of second cases. Our first case, this 9 o'clock case, Larkins versus Harris, I don't think you need to get involved. Have you been helping Mr. Harris with any of his back rent?
I believe that we don't have a Mr. Harris on file.
All right, then I won't need your help till 1:15. But boy, we got a lot to do. Hopefully you have a lot of good news for me.
Partially.
Some good news is better than none, I guess.
Yes.
Anyway, we're really booked this afternoon because of the vacation schedule. We had to cram a lot of stuff in. So we've got landlord, tenant, general civil, and small claims. But we'll hit the ground running right after lunch. But I don't think you need to get involved in this case. If I need you, I'll send you an email.
Right.
But
Sounds
I think
good.
you got plenty of other work to do. I'll see you just after 1, okay?
Okay. See ya.
All right. Have a good morning. Thank you.
You too. Thanks.
That's our new housing advocate from Keystone. She's doing a real nice job. And once we figured out what the rules are.
Yeah, I was going to ask her, and I think what I'll do is contact her. I don't know if you remember, I had that Mr. Jonathan Stevens, and at the last hearing, he was supposed to appear and he didn't, and I took a default. And I remember, I don't know if you remember me just putting my head, because he told Bettina that he had enough money to pay himself, and I don't think he does. So
and even if he did, he was eligible probably for some help.
Right, and so the default's up today, but he called me on Friday, and I spoke with him for a few minutes, and I said, call them right away, call them right now. And so I'm hoping he did, and I will try to make some contact. I'm gonna, before I do anything here, I'm gonna make sure that he's exhausted everything.
All right. We're just lining up our participants. Mr. Harris, and good morning, Mr. Davidson. I've got 2 things set for 9, and I'm gonna try to do the other matter first, and then we'll address your matter. So, Mr. Harris, I didn't forget you. I'll put you back in the waiting room.
No problem.
Good morning, Matthew.
Good morning, Your Honor. Happy Monday.
Good morning.
Happy Monday, John.
Good morning, Matt. How are you? Good to see you. At least it's sunny, partially sunny.
One of the problems, John, we have is we try to start right on time. So we go through everything, do a default, then 7 minutes late, the defendant shows up.
Yeah, I appreciate that you start on time. I was just telling my wife this morning that you're one of the judges that starts right on time. I like that.
Well, we try to. It makes it easier for everybody to understand what to expect.
Exactly.
And they're paying me this much, so the least I could do is show up on time.
I didn't have that conversation with my wife this morning. You know, really, Judge Middleton wasn't even part of our concern or discussion. In fact, he didn't even rate the list.
I don't blame you.
What can we talk about this morning?
Well, let's talk about Mr. John Bradshaw's civil matter. It is 9 o'clock. This is file 21-4GC. It's entitled HZ CNAC Inc., J.D. Byrider of Kalamazoo versus Ashley Longacre and John Bradshaw. It has to do with the sale of 2007,
Joe Wilson.
not John Bradshaw, Joe Wilson. John Bradshaw obviously is the plaintiff's attorney. It has to do with a 2007 Ford Explorer that was bought on a retail sales contract that failed. The car was either returned or repossessed, and the plaintiff has filed a complaint for money damages in the amount of $12,393 plus cost, interest, and attorney fees. The lawsuit was served on both parties. Mr. Wilson failed to file an answer, and he was defaulted, and there is a default judgment in the file against Mr. Joe Wilson dated March 3rd. Ms. Longacre filed a handwritten answer, which we get a lot of these, especially in these auto cases. I'll just read it into the record. I, Ashley Longacre, do not think I'm liable for a car that broke down on me every other week. They say they have a warranty, but they gave me a hard time to fix it. Every time they fixed it, it broke down the next week, leaving me and my children stranded. They turned around and sold the vehicle for $2,000, shows you the value of the vehicle. This is predatory lending. They take advantage of low-income people and blame them for returning a vehicle that you beg them to fix. Anyway, this is like a standard complaint in these cases. They get the cars, they're sold as is, they don't work or they break and they can't make a payment and they're at high interest rates and they get sold at auction at a reduced price and they're stuck with the shortfall. The contracts are very old. They've been challenged multiple times, and they're not a very good deal for the purchaser, but nobody made them purchase the vehicle. At any rate, because she did file an answer, I set the matter for a pretrial this morning, and she isn't here. Mr. Bradshaw, are you going to ask for a default?
Yes, Your Honor. And you cite this yourself in the pretrial order in the 2405 that if they do not appear for a hearing that's scheduled, they can ask for a default. I will submit a default if it's the pleasure of the court, and then if she contacts me, then maybe we can work out something from there.
All right.
We do have that judgment against the other defendant, and if he's...
Yes, I'll just mirror that.
Yeah.
Damages in the amount of $12,396.46.
Yes, thank you.
$12,393.46. $261.39 in costs. $75 attorney fee. $12,729.85. Joint and several with Joe Wilson. I'll indicate you will submit a judgment. All right, I guess that's all we can do. It's 12:09:06. She isn't here. If she does come in at some point later, I'll direct her to you.
That'd be great.
But in the meantime, we'll simply do the default.
All right, thank you, Ron.
All right, thank you.
Have a good day.
Thank-
Mr. Fleeman will be with you this afternoon.
All right, and we've got a very busy afternoon, as you heard me tell Bettina. We'll do what we got to do. Anyway, I'll see somebody this afternoon. It's good to see him too.
Good to see you.
John, tell Ty said Matt Davidson said hi.
I will tell him.
You can tell him we
All right,
settled our
thank you.
favorite case.
Tell him what?
We settled our favorite case. You can
Oh
just tell
yeah,
him
that was a legendary case.
they are.
Well, it's good when they settle, to be sure.
Right.
All right, thank you.
Both of you have a good one.
Matthew, we've got the defendant in your case, but we don't have the attorney.
Well, in fairness to, I'm not going to ask for a default. We were on the phone with Lapita and set it for 9:30, agreed to adjourn it to that, and he probably
Oh,
just
so
didn't
business-
notice that the order changed it by half an hour, and I think maybe my clients didn't either because I called them and told them right away. So I'm just letting you know that that might be what's going on.
All right, I don't know. I didn't catch that either.
I'm just letting
So-
you know that we talked and it was on for 9:30, and he's probably
When was it
relied
on for 9? When was it on for 9:30?
when the three of us were all on a conference call together with Lapita trying to pick a time to reschedule it.
Well, it
And-
was set for 9:30, and I crossed it out and wrote 9. So
I know, I'm
think-
just saying, he may not have noticed that. I'm in
Oh,
fairness
I
to him.
see. I see.
He signed a
All right.
stipulation that said 9. And
Yeah.
then, so he saw that number.
All right, well, I'll put you in the waiting room, and when he logs in, I'll bring Mr. Harris back, tell him what the deal is. I wanted an hour for this, because I got another ugly hearing that starts at 10. Good morning, Mr. Harris.
Morning.
There's reason to believe your attorney didn't think this hearing was until 9:30. So he's not here yet, but he may think there was an earlier notice that said 9:30. It got changed to 9.
Right,
Anyway,
right.
he's not here yet. I'll put you back in the waiting room. As soon as he logs in, we'll bring you in.
Okay, thank you.
All right, Matt, I'll put you in the waiting room and I'll wait for him to come in. Darn it.
Attorney Calvin, Mr. Houston.
Okay. There was some confusion about whether it was set for 9 or 9:30.
Correct.
Well, I wanted it set for 9, so all right, we'll get him here in just a moment, thanks. Oh, Lupita?
Yep.
Let me give that. I didn't show up. We should be ready to start up here again in just a moment. Shut the recorder off. I'm recording a bunch of nothing. Well, come on.
Morning.
Good morning, Judge. I apologize for that.
Good morning. Well, there was some reason for confusion, so no need to apologize. I wanted to do it at 9 because we had a lot going on this morning. I have another hearing that starts at 10.
Don, I defended you. That'll be $50.
All right, send me a bill.
All right, well, let me call the case. We are live on YouTube and we are recording this. We're on the Zoom platform. This is entitled Scott Larkins versus Carl Harris. Mr. Matthew Davidson is here on behalf of Scott Larkins, and Mr. John Calvin is here on behalf of the defendant Carl Harris, who is present. This matter started quite some time ago as a termination of tenancy action filed by Mr. Larkins. The notice to quit was actually served in December of 2020. The defendant raised a number of issues on his own, and then he hired Mr. Calvin, who filed a number of motions and a counterclaim. Mr. Larkins then retained Mr. Davidson, who answered the counterclaim. there was a request for termination of tenancy, and I issued an escrow order. The defendant did not comply with the escrow order. He paid 1 week of rent. And so I made a finding back in March that he had until April 1st to vacate the premises. And it appears that he's still there. Are you still in the house at
47 East
there?
Michigan.
Yes. All right, so he's there, he's not paying rent. There's a writ of eviction order effective April 1st, and there are claims and counterclaims having to do with money damages, which are unresolved. So I blocked out what I hope was an hour today to try to address this. Mr. Davidson, I'll start with you. What's your position here?
The allegations in the countercomplaint, even if true, are not defenses to the eviction. I think the court just alluded to that. They may be independent causes of action, but we used to get these in the bank collection cases where people would come in and allege the violation of some federal act, or, you know, the this or that truth in lending. And while they may or may not have been administrative challenges to the bank, they were not defenses to why the person wasn't paying the loan, and it's the same thing here. These do not prevent an eviction. Anyway, that would be my at least not under a 30-day notice, which was the case in the instant case. So my position would be that the court's order of eviction stands, and if a writ has been issued, that it's enforceable. And then I'll talk about the...
And we have the unresolved issues regarding money damages or other. Mr. Calvin, what's your position? Mr. Harris, are you still here with us? I lost your video.
Yes, I am. Can you hear me?
All right. Yes, thank you. Mr. Calvin, what's your position?
I think that's correct, Your Honor. As to the possession of the premises, I don't think there's any issue that I don't think the moratorium applies in this case.
No.
The court's given some additional time, so I don't think that we have any argument as to the possession of the premises, but the counterclaims, as Mr. Davidson said, are separate from that, and we'd ask for some limited discovery on those counterclaims, but I think those are independent of the possession of the premises.
All right, well, let's talk about this with Mr. Harris. Mr. Harris, do you know effective today the sheriff could come throw all your stuff out in the street?
I'm aware of it now.
You've been living there for many months without paying any rent. I ordered an escrow order and you only made 1 week's rent payment and you haven't made one since. I made a ruling, here's Mr. Larkins late to the party, some months ago that said if you weren't out by April 1st, you were subject to eviction. So that was last Friday. So effective today, they can get an order and have the sheriff put your stuff out. Have you made any effort to attempt to move?
Yeah, I had got a storage. I had moved a lot of my stuff to storage, and I'm trying to get an apartment at Riverside Apartments, and I'm just waiting to hear what's going on with that. Supposed to get a call back today to see what's going on, to see if I could get my apartment.
Well, that's sort of an answer. It's not a complete one. Mr. Larkins probably also was confused as to when this hearing was. Mr. Larkins, what's your desire? To have an immediate writ of eviction?
Yes, Your Honor. I'm sorry, I thought it started at 9:30.
Well, there was some reason for confusion. The attorneys did a stipulation to move it to 9:30 without asking me, and I moved it back to 9, but the original printed notice said 9:30.
My apology.
Well, you don't need to apologize. There was reason to be confused. So, Mr. Harris, your landlord doesn't feel very charitable toward you, You haven't paid any rent. You filed all these counterclaims. He's had to hire an attorney to defend them. You haven't moved, and he wants you to move immediately. And then we're going to argue at expense of you and them about who owes who how much money.
I wanted to ask to see if Scott Larkin will allow me to at least have one more day because I'm off tomorrow and I'm a manager and I close at Burger King tonight.
Yes.
Off work tomorrow, and I should be able to find out what's going on with that apartment by the end of today.
Well, that was my next point. I wondered whether there was any room for
So you're,
some sort of
I guess, Your Honor, is he saying that he's going to be out completely by the end of tomorrow? If I give him one more day?
Mr. Harris?
I'm waiting for the apartment to give me the answer, but yes.
No, no, that isn't what he's saying. Mr. Harris, he wants you out. You've been hanging on by your fingernails since December. You haven't moved, you haven't paid any rent, and I ordered on February 26th, I think, that you'll be out by April 1st, and you haven't got out, and you're saying, well, I'm waiting to hear from somebody else. In the meantime, you're living in his apartment and you're not paying any rent, and you're suing him for thousands of dollars worth of damages. So he's probably not real cordial. So if he does what he wants, the sheriff can come in by 5 o'clock today and put all your stuff out on the curb. In the meantime, you're saying, well, I'm waiting to hear whether I got an apartment, which you probably don't. There's a long waiting list at Riverside. You're in the middle of an eviction, which may prohibit you from being admitted as a tenant at Riverside. So you don't have a real good plan. So the good plan would be to work out some agreement to settle this, short of you having a writ of eviction on your record, which would prohibit you from getting into subsidized housing. So I'm gonna put the four of you in a breakout room to discuss that very issue. Mr. Harris, by the letter of the law, if Mr. Larkins wants a writ of eviction today, I will sign it. You're not just about to move into Riverside townhouses. And if they find out you're being evicted, they aren't going to let you in. That's the reality of it. Mr. Davidson, do you want to talk to Mr. Calvin privately, or do you want me to put all four of you in the room to discuss this?
Your Honor, we had already talked about discussions, and we haven't had them yet, but we don't really need to be in a breakout room. If you wanted to go on talking about a pretrial of the rest of the economic issues, Mr. Calvin and I can speak separately. He's been very professional in all my dealings with him, and I don't doubt that we could have a nice conversation.
All right, well, the writ of eviction could be tied to the rest of the complaint and counter-complaint. The underlying question is Mr. Larkins going to ask for the writ of eviction immediately, which he's entitled to?
Yes.
And then I have the secondary concern that writ of eviction prohibits Mr. Harris from getting in to Riverside townhouses or other federally subsidized housing. So it's a lose-lose proposition for him. We can then set a half-a-day trial on the money issues, but in the meantime, he's sitting on the curb. Mr. Calvin, do you have any input on that point? You're on mute.
Sorry, I was muted. If
Yeah.
you could put Mr. Harris and myself into a breakout room for just 2 or 3 minutes, I think that would be helpful.
All right. Take as much time as you need. My next hearing is until 10, but I'll put you in here and let you discuss that with him.
Right here.
they're in the breakout room. Mr. Larkins, I'll put you guys in the waiting room rather than have you sit here on an open screen. Do you want to, well, I'd only open one room.
We're all right, Your Honor. We'll wait till he come back.
All right. All right, we're back in hurry up and wait mode.
Oh, it looks like Mr. Davidson and his client are in another breakout room, Your Honor.
Well, I put them in the waiting room.
Did you spend it with?
Is it possible to go into a breakout with Mr. Davidson for just a moment?
Yes, certainly.
Or we can talk on the phone.
Well, I'll put you in the breakout room.
All right.
Um,
Sure. I've already talked to Scott. I know what his position is.
All right. All right. Mr. Larkins and Mr. Harris, I'll put you back in the waiting room. Mr. Harris, you've been out of the waiting room about 12 times, but been very patient. No, thank you. And Mr. Harris, I'll put you in there also. All right, we're back to hurry up and wait. In the meantime, I'll stop the recording. And I'll review some of my 11 o'clock sentence files. Well,
Hi,
let's
Judge.
bring.
Is
welcome
Mr. Harris,
back.
I'm sorry.
Let me bring the parties back in here.
Yeah, if you could put Mr. Harrison and myself into a breakout for one more minute, and I think we'll be ready to go.
All right, very good. Let me close the room and reopen it. Mr. Harris, I'm going to put you in a room with your attorney so you can discuss what they discussed. So you'll go into a breakout room again.
Okay.
Good morning, Mr. Welch.
Good morning, Your Honor. How are you?
Good. We're wrapping up our 9 o'clock. The parties are back and forth in and out of the breakout room, but you're in the right spot. I'll put you in the waiting room. I think we're just about to wrap this one up.
Okay, sounds good. I always like to check in early.
All right, I appreciate that. Thank you. A lot of buttons to push. All right, we're back on the record.
Are you pushing my buttons?
Yeah, I'm pushing my buttons, all right. We're back on the record in the matter of Larkins v. Harris. We've had a number of breakout room discussions between plaintiff and defense counsel and then the parties. All the parties are back. Mr. Larkins is back. Mr. Harris is back. I'll defer to you, Mr. Calvin. What's our current status?
Your Honor, and I'll leave some time for Mr. Davidson to clarify if there's anything that I get incorrectly here. We've discussed and Mr. Davidson and I will craft an order in this regard, but the parties have agreed that Mr. Harris will vacate the property by noon on Friday, April 16, which is next Friday, and will clear out all of his belongings from the house and will leave it broom clean. And if he has not cleared out by noon and has not removed his property and left the premises broom clean, Mr. Larkins would be entitled to a judgment for the cost to clean and would be entitled to have an order of eviction executed anytime after noon on that day.
What about all the rest of the claims?
Oh, I'm sorry. And the counterclaim would be dismissed. This would be a full resolution of the matter.
Well, there's still an issue regarding money damages of the 13 or 15 odd weeks that he hasn't paid rent. What's
Your Honor, may I speak to that, please?
Yes, please.
the idea was that that would be washed out in the settlement of the complaint. He moves out by noon Friday, April 16th. If not, the defendant will confess judgment as costs. And the judgment for costs would be the actual costs of the eviction, both the procedure and the process of the eviction, and any cleaning of the apartment that's necessary. That would also include damages. I'm just looking behind Mr. Harris, and it looks like it's in pretty good shape, but you know, if it's damaged other than ordinary wear and tear. So all that Mr. Larkins needs to do is to submit a bill of costs to the clerk, and he'll get a judgment for those costs only. He can provide documentation, but that's the agreement.
Mr. Harris, this is a very generous plea agreement. And it's what needs to happen to save your circumstance. I want to repeat, Mr. Larkins can get a writ of eviction right now, and I would sign it. And they would come move you out by 5 o'clock, and you wouldn't be able to get into Riverside. They're now giving you 11 more days to move out. You dismiss the counter complaint, they forego the rent claim, which is around $3,000, give or take, and they can claim the eviction costs and any damage. That way this comes to an end. We don't have further hearing regarding the issues raised in the complaint and the counter complaint. The matter will be over and done with. Now, you certainly can move prior to
That date.
And when you do move, you need to turn in the keys and give your forwarding address within 4 days of your moving. I told you this before, but I'm going to tell you again because we've reached a consent judgment. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights to have a hearing on the matter, but you have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. Do you understand?
I understand.
And so, are you agreeing to move by the 16th of April at noon, or be subject to being evicted?
I agree to move by the 16th.
And you agree to dismiss the counter complaint?
I agree.
All right, Mr. Larkins.
Yes, Your Honor.
I don't distrust what the lawyer said, but it's always a good idea to put the parties on the record as well. You agree to give Mr. Harris till April 16th to move out by noon that day, is that correct?
Yes, Your Honor.
And you understand if he doesn't move, you can ask for a writ of eviction at 12:01.
Yes, Your Honor.
And you're also agreeing to forego damages for back rent, but you are preserving damages for damage to the unit and costs of eviction. Is that correct?
The only question I have is the stuff that he has paid to you. Do I get that then?
Yes, that should be in the order. The escrow funds shall be remitted to the plaintiff.
Thanks. I forgot about that, Scott. Good
Me
point.
too. All right, who's going to do the order?
We will. I'll prepare the order as plaintiff, and I don't know if it's prevailing party, but I'll do that.
All right, Mr. Harris, you or Ms. Calvin, you agree?
Yeah, we can work together, Your Honor, versus via email.
Well, I appreciate the work that you guys have done. This is the resolution that needed to happen here. Problem is it needed to happen about 2 months ago. But we got there. So I'll await the order, and hopefully this will resolve it.
Excuse me, Your Honor. I wanted to make sure they wanted the house broom clean. I wanted to make sure and ask Scott, does that involve the basement?
I want all your stuff out of there, yes.
Right. I'll get all my stuff. What about the stuff that was there when I moved in? which was in the basement only. That's not my stuff.
I mean, when we were in the basement the other day, there wasn't hardly anything in there, so I don't know what you're
Right.
talking about.
Okay. Okay.
All right, that completes the record on this. Mr. Calvin, maybe someday I'll meet you in face to face, but it's been nice dealing with you. I'm going to remove everybody one by one, and we'll start our next hearing in just a few minutes.
And I
you, Your
look forward to that, Your Honor, as well. I told my
Okay,
wife
Your
how
Honor.
nice Three Rivers was when I came to visit, and I'm sure we will be back.
Come in the summertime. It's a lot nicer in July than it is in March.
We will do that, Your Honor.
All right, thank you. See you, Matthew. All right, that resolves that case, which is a very good thing. All right, only one of the parties for the next case is here, so we'll stop the record for a moment, wait for them to log in. Well, our next matter is set for 10. It's 10:02. And only the plaintiff's attorney is here. Just checking in. I'm on time. They resolved my case.
Okay.
And so you're not held up for me. I'm waiting for the plaintiff to show up. So
Okay.
if they don't show up in a few minutes, we'll go on the record and make a record. But in the meantime, I'll put you in the waiting room, and I'm just sitting here reviewing this file and others. So
Okay.
I'll see you in a couple. If they aren't here in about 5 minutes, I'll bring you back in. Good morning.
Morning.
I've been sitting here contemplating the meaning of life for 5 minutes, waiting for you to show up. I'll bring Mr. Welch back in.
Yes, Your Honor.
All right. Very good. Mr. Polaris is here now, so we can begin. This is file 201153GC. It's entitled Allied Bank versus Leo Mitchell. Mr. Eduardo Polaris is here for the plaintiff from the Shermetta Law Group. Mr. Harold Welch is here from Legal Aid of Western Michigan on behalf of Leo Mitchell, who is not present. This case started way back in October. Then it got continued until January, and then February. We were here on February 22nd, made a record. The motion for summary disposition was continued until today. The defendant did file a response to the motion for summary disposition, did file an affidavit and a brief, and it's the defendant's contention that this is a fraudulent transaction. A little bit complicated because the actual transaction was in the state of Indiana. Mr. Polaris, this is the time and date for your motion for summary disposition. Do you wish to speak to it any further beyond what was in the pleadings?
Judge, I think the motion is pretty clear. Just would respond to defendant's brief. He raises some interesting issues. However, Judge, this is a contract case. Defendant tries to bring in parole evidence of potentially some verbal discussion that occurred. I would just remind the court, even in Indiana, when you have a contract, the plain language of the contract is controlling. Parole evidence is not brought in unless the contract is vague or ambiguous. In this instance, the contract is very clear. The defendant was purchasing a vehicle. There was no trade-in anywhere in that paperwork. And that is the crux of defendant's entire defense, is that he had an outside oral agreement that's not reflected in the written agreement. Our position is, and we believe the law is well settled on this, if it's not in the written agreement, it didn't happen. And that's what's before the court today. And there's no evidence whatsoever being provided that shows that the contractual agreement itself has any fraud, any information that was misleading. It's very straightforward. Defendant signed that contract, he entered into it, and now essentially he wants to renegotiate it with an outside oral agreement supported by parole evidence that's not submissible.
All right, thank you. Mr. Welch?
Yes, Your Honor. It's interesting that all these adjournments we've had was so plaintiff's counsel could confer with his client about the affidavit, because we gave it to him back in December. I would communicate with plaintiff's counsel. He would say he would talk to his client, then he never got back to me. He didn't call me after I filed my brief last Monday. So here we are now in a motion, waiting for the court to do something, because apparently the parties cannot resolve this. I think it's clear from our affidavit, Your Honor, that this was a fraudulent transaction. Counsel for the plaintiff says the law is well settled. He hasn't submitted any Indiana law that says fraud in the factum or fraud in the inducement does not void the contract. So I think it's clear from our brief that this is fraud under the law of Indiana. The facts are undisputed that the salesman purposely defrauded Mr. Mitchell by getting him to sign a contract that didn't state what the parties had agreed to. So we would ask for judgment in our favor, Your Honor, at this time. Thank you.
All right, thank you. Well, plaintiff claims, perhaps accurately, that this is a contract agreement. I'm not going to do a share screen, but these contracts are full of boilerplate, very small print. The defendant apparently did sign it. He's a very unsophisticated defendant, so to say that he understood everything that was in the contract may be a stretch. Plaintiff alleges that the parole evidence rule doesn't allow any extraneous evidence, which would mean you'd never be able to bring a fraud complaint. If the contract is the contract is the contract, you don't get to say, hey, I got cheated or I was defrauded, because that would be parole evidence. The defendant, once he got legal representation, filed an appropriate response to the motion for summary disposition and filed a sworn affidavit stating his allegations. And just on its face, the whole transaction is kind of screwy. He goes in on some sort of a prize solicitation, finds out he didn't win a prize on some scratch-off ticket. The next thing he knows, he was signing a contract for a car. He says he immediately tried to rescind it, had the car for only 2 days, and then the car was sold at auction with a shortfall, and they're requesting the balance from him. There are factual disputes here. And when Mr. Mitchell tried to raise these himself, he was doing the best he could, but he's not a lawyer, and I felt that he needed representation, and legal aid has accepted him as a client and filed a response. So the contract may say what it says in teeny tiny print for lots and lots of paragraphs, and the defendant did sign it. And I enforce these contracts regularly, not just from this company, but a number of these used car sales plaintiffs. And the contracts have been certainly challenged over the years and have sustained most of those challenges. But I do find that there are factual disputes in this case. I don't know whether the plaintiff, the car dealership's out of business. The salesman, whose name is not known in the pleadings, don't know whether that person is even there or any of the witnesses are available, but there are factual issues regarding fraud and a knowing signing of the contract, and we don't know, no one has cited to me whether there's a 3-day cooling off period in the state of Indiana. So there are factual issues. And the motion for summary disposition is denied. And then I guess our next step is set it for trial, set it for a pretrial, further discovery. What do you suggest, Mr. Polaris?
Judge, I need to communicate to my client today's results. I'm not sure if this balance is something they want to go to trial on. I would ask for maybe another pretrial in about 30 days and maybe trial in 60, and we'll go from there.
Mr. Welch, I'll ask you to do the order.
Okay, Your Honor.
Do you have any objection if I set this for a pretrial in 30 days and he communicates with his client? And
No,
then
Your Honor. I would
if it is
just,
resolved,
I'm sorry, what'd you say?
then we could set a trial if it's not resolved.
Right. I would say as long as the order today reflects that you are continuing our right to file an amended answering counterclaim, and you'll address that in 30 days. In other words, if we don't get it dismissed in 30 days, then I would like 21 days after that to file an answering counterclaim.
All right, you can put that in the order. All right, today is April 5th. A month from now would be, let's go to May 10th. At 9 a.m. Plaintiff reserves right to file counter complaint. All right, we'll continue this. We've been kicking the can down the road since December. Suppose a few more 30 days won't hurt anything. And
all right.
Oh, that's great. All right. Mr. Polaris can discuss this with his client, see whether they can locate the witnesses and what their position is. If it's dismissed, you don't have to wait till May 10th. If they decide they're going to dismiss, you can go ahead and file the dismissal. If it isn't dismissed, We'll have our hearing at May 10th at 9 a.m. and discuss what we're going to do at that point.
Very well.
All
Thank
right.
you, Your Honor.
All right,
Thank you.
thank you. All right, we have a number of criminal sentences, about 7 of them, starting at 11 a.m. So we will stop the record here. And stop our live feed. We'll be back shortly.